Good evening. A warm welcome to you on behalf of Citizen Justice Forum. आज का जो टॉपिक है, it is third in the series of auditors report and how to audit in a cooperative housing society. हमारे आज keynote speaker है Mr. Ameet Israni. He is a chartered accountant, a practicing chartered accountant, and he will take on from here. Good evening.
Good evening, sir. Viewers, good evening. Today, the third series. We have done part 1 and part 2, and what we are doing today is a part 3 on auditor's role in a cooperative housing society. From the information available in the media and other places, nearly 7,000 to 8,000 societies are in the process of redevelopment, and more than 70% seem to be stuck in some kind of an issue or the other. Most of the issues that start off is because when we go in for redevelopment, we see a balloon in the sky and we start feeling that, oh, if I have a 500 square foot, I'll get 1,000 square foot and I'll become a millionaire. So everybody clamors for going in for redevelopment without actually studying what it is all about. That is where the problem starts. And then we have people who are not really very conversant with the rules and regulations and the finer prints, who then add fire and oil to the story, and then we have an imaginary castle in the air. In order to ensure that people understand the finer nuances of what redevelopment is, I'll take you through various boxes which will make it easier for the viewers to understand. There is box 1, which is the members of the society. Box 2 is the managing committee of the society. Box 3 is the registrar, who is the person who's supposed to oversee the procedure. And part 4, of course, is the person who will do the redevelopment, which is the builder. In between, we have to make a connect of how these 4 have to be connected. We hear issues like you need a lawyer, you need a PMC. I'm putting all that in the box of the redeveloper, which is the builder, because eventually it is the builder who lands up controlling the PMC and the legal documentation for reasons which are very simple, because the members don't understand the rules regulation and they have confidence in the builder who takes the charge, but thereby also tends to create a situation where profit is the motive for the builder and all assurances will be given and we may get stuck. Now, coming to the members, the first box, what is redevelopment for the member? In our bylaws, there is nothing called redevelopment. This is the bylaw under which we are covered. And the bylaw does not, I repeat, bylaw does not speak of the details or the procedure in detail or specifics about redevelopment. Then we have the Cooperative Society Act, which we are following, which also does not directly speak about the process of redevelopment, but talks about the procedure in one section, which I'll come to. The registrar I will leave for the time being, and the developer or the builder I will leave for the time being. Coming back to the members, the society's management vests with the managing committee, a duly constituted managing committee, not an ad hoc managing committee, not authorized officer run managing committee when it comes to redevelopment. So if you are going for redevelopment, your committee should be a duly constituted managing committee. So once you have a duly constituted managing committee, their quorum should be complete. Now, a managing committee has to work within the Act, rules and the bylaws. When a person becomes a member of a society, he fills a form and there he undertakes that I shall abide by the rules, Act and the bylaws. the provisions of the Rules Act and the bylaws. Which means obviously that neither the member nor the managing committee can do something which is beyond the bylaw. Now in the bylaw, the procedure for redevelopment is not mentioned, either directly or indirectly. There's just a meek reference to it which came after 2014 in bylaw number 175, and there's a slight mention under bylaw 155 and 157 where if the building is old, cannot be repaired, then the committee may go through the process of redevelopment under certain conditions, and those conditions I will explain. We have a bylaw 5 which deals with the object of the society. A society, like any other body corporate, can only carry out activities which they are permitted by their object clause. They cannot go beyond the object clause. If they do so, then they are committing an offense. What is the object clause? Object clause is the clause which gives the power to the society to carry out activities for which purpose it is formed. There are three main purposes for which cooperative society is formed. The first purpose is to get conveyance. The second purpose is to manage, administer and manage the building. And third is to carry on cooperative activities. The other three main, and fourth of course is the education to be given to all the people in cooperative. So we'll take the first three. Conveyance is the first purpose for which, the first object for which the society is formed. Now, whenever anybody goes to the registrar, the first thing that the registrar ought to ask, have you got your conveyance? If you are not able to get the registrar, then you have a problem. The registrar's duty and function is first to ask the member before he takes any matter of the society, either it's a member or the society themselves. Have you complied with the object clause? If the answer is no, then registrar must ensure that before he comes for any other business, any other activity, the first object of the formation of the society is complied with. Today we have got societies which are more than 20 years old, 25 years old. There is not a whisper from the registrar's office when you go there. Why have you not complied with the first object? Then how do you exist? What have you been doing? That is where the first problem starts. The second problem starts when people start feeling that, oh, if I go for redevelopment, I will get a big house, my value of the property will go up, I'll become a millionaire, or whatever it might be. But does the law permit you to do that? Answer is no. The reason is the cooperative society is formed for the purpose of managing the building. So we form a society to live in a building. A society is not formed to break down a building. That is not the purpose or the object of a society. So when bylaw number 5 says to manage, then we have bylaw number 155 and 157, which talk about it is the duty of the society, of the committee, to ensure that the building property is in a properly managed manner. It does not talk of breaking down. It says you have to repair and manage and ensure that all the properties are kept in a good condition. And which is why we have sinking fund and we have repair fund. So these two funds are collected over a period of time so that we have some money to ensure that the property of the society is kept in a correct condition. Then there is a further clause which says, or redevelop as per government order. 155, 157, when you read them together, you will find there's a word, or redevelop as per government order. Nowhere does it say to redevelop it as per general body order. So all this myth that we have, general body has majority or minority, when the object does not permit that particular meeting, then whether you have a majority or a minority would become a non-issue. Unfortunately, such matters or such information at the time the matter goes to court I haven't seen a single judgment among 40 judgments that I have read where the lawyer is telling the court that how did the society go into redevelopment when the bylaw does not permit it. So where is the question of majority and minority? This matter started in 2009. So prior to 2009, there was no rules or regulation. Anybody would just go. Courts would pass order, like we have a Girish Mehta judgment, which is 2008, which is even being quoted today. If there is a majority, then majority prevails. But this Girish Mehta judgment of 2008-9 was subsequently challenged in the Supreme Court. And Supreme Court accepted that even the minority has a right. It overturned the Girish Mehta judgment, and in fact, the people who complained in Supreme Court got 10% more area and a higher corpus than those who did not complain and blindly go. Now, unfortunately, the Supreme Court Girish Mehta judgment doesn't seem to be on the website. For what reason, I do not know. So it took some time before we got that judgment. And a clear reading of the judgment would show the Supreme Court has accepted the fact that even a minority who has two rights, one is a membership right and one is the property rights, have a right to getting some parity. And they got the parity. We also have another judgment of recent where one single lady, senior citizen, went to complain. And she was heard, and the MHADA, CIDCO, BMC were told to make new rules and regulations to safeguard the interest of the senior citizen. This is a judgment currently of 3 months ago, March, April. So there are, if correctly presented to the court, you will get the order in the way that you should get. Now, when we come down to, then what is the way out? If the people who own the land now decide as owners of the land that yes, we want to redevelop, then in 2014, a new bylaw was inserted, bylaw 175. Prior to that, we had only up to bylaw 174. So bylaw 175 was inserted at the very end in 2014. And I will read the first paragraph of bylaw. Redevelopment of the property / building of a society, including vacant spaces, shall be done strictly in accordance and conformation with the resolution number so-and-so, dated so-and-so, of the Maharashtra Cooperative Society Act issued under section 79A. So 79A first took its birth in the bylaw in 2014, referring to the resolution of 2009. Now, what is this 2009 resolution and what is the 2019 resolution has to be understood. 2009 was the first attempt to bring some sanity in the redevelopment, because a lot of issues took place between the builder and the public and the managing committee, either because of clash of interest or because the public was in the myth and trusted the builder, or the builder was under the myth that yes, I can do X, Y, Z, whereas probably he could not achieve that. A lot of big promises were made, which they could not comply with. And thereafter, in 2009, the complaints increased with the government. And 2009, they came out with a document under section 79A. Now, question that arises is, everybody must understand what is section 79A. If you don't understand 79A, then the question will come, is this mandatory, not mandatory? Is it discretionary? Is it substantively to be followed? All those answers will be given once you understand what is section 79A. Section 79A is a section which gives the power to the government to issue direction. Now, this particular section is inserted by the assembly when the law was being made. All the laws do not have this section, but anywhere where a particular law has this section, it is given by the lawmakers as a delegated authority to the government to continue making the law in the interest of public interest, in the interest of the welfare of the citizen, in the interest of better working arrangement. And once it is made under 79A, then it has the force of the law. It is a delegated, extended jurisdiction given to the government, and which is then to be complied with. There are so many directions issued under 79A. We have the direction of non-occupancy, where 10% has to be charged. That is also under 79A. In that, nobody mentions whether it is substantial, not substantial, or whether it's discretionary, not discretionary. It is to be followed, and if you don't follow, then the punishment of 79A has been applied. There are other things like premium. You can't take more than 25,000 as premium, which is also issued under 79. Then you have other directions issued under 79, which is for satellite or mobile towers, holdings, of how the income is to be shared and divided. That is also under 79A. That is under housing. Now, even under non-housing, because Section 79 is a generic law applying to all cooperative societies. So even other cooperative societies, for the functions that they are preparing or doing or completing or conducting, have got instructions from the government under 79. We have got for taxation purpose, we have got for your purpose of finding out sugar prices, setting of sugar prices in sugar cooperatives. They're issued under 79. So there are a lot of societies, non-housing, who are also issued direction, and they are all mandatory. So there is no reason why we should talk of whether 79A is mandatory or not mandatory. Second thing that is very important to understand is, how do we decide? And is there a judgment which confirms my statement? The answer is yes. There is a judgment of the Bombay High Court which says that if the statute states that government power has been given, then it is mandatory. But if the statute does not state that clause in any of the sections, then any direction given by the government is then discretionary and not mandatory, or to be followed whichever way to be done, depending on society to society. So that is the first clearance one must get. Second thing is that one judgment came on between 2009 and 2019, which said that the document issued, the notification or direction issued under the 79 for redevelopment has the word should. And if it is should, and general body being supreme, they have to follow. In contradiction to this judgment, there is another judgment of the Bombay High Court which says that if the word used is shall, then it is mandatory, and if the word used is should, then it is not mandatory, even in a direction or guideline, whatever we may call it. The government then took notice of that order of the High Court, and the 2019 judgment corrected that, and all the clauses now have got the society shall, the member shall. So this issue of should and shall has been corrected in the 2019 order that has come. And 2019 clearly states that this is a direction. It does not say that it is a guideline. The only area where a savior will come would be if any of the clauses don't apply to the particular society. For example, if you are going for self-redevelopment, then the society which is the developer would not have to give any bank guarantee because it is self-redevelopment. So similar to that, if there are any other clauses among the 20 clauses which are not applicable to a builder developer, then they would be allowed to tone down, tone up, exempt, depending on situation to situation and legal advice that they may get for their particular society. Otherwise, if it is a builder related, then it has to be followed. Now the question is, why are you making it difficult for a builder? Why are you making concessions when you are doing it yourself? The answer is very obvious. When you are dealing with a third party, and managing committee is the trustee, managing committee is not the owner of the building. Managing committee does not have all the rights of each member. A member has two rights. One is the right of membership, and second is the right on the property. So you have a document which is like a sale agreement or a gift document or whatever you might call it, and that document gives them the right title into the capital interest of the property, and the membership gives them the right of membership. Now, the next thing which members must understand, because what I'm talking now is all about members, and members must hear this. If you have missed something, please rewind and listen again. A member is given a share certificate. Now, what is a share certificate and what is the benefit of a share certificate? What is the advantage of a share certificate? The share certificate is a document which says that the rights of the building, which was given by the builder by an agreement to sell, is now transferred to me, to the society. And I am now going to give an occupancy right to the member. So what member gets by virtue of a share certificate, he retains his title of transferability, but the right of the building structure remains with the society, which is why the insurance of the building is paid by the society from the common fund. The structure insurance is not paid by the member. So the insurable interest in the building is with the society. The transferability rights is with the member, and member has an occupancy rights to stay in the building. So there are three things which must be understood very clear. So when we are actually talking about redevelopment, then where does it come in? Where does this argument fit in? Because the society has to give you occupancy rights and you are dehoused. I'm now using the word dehoused. You are not evicted, you are dehoused from that particular flat, and the society has to give you an occupancy. You are given rent. So here is the money, please go and rent. This is the amount given to you, and you will have the right to stay in a house of your choice till we rehouse you. So in a redevelopment process, there are three units which you must look at. One is dehousing, not eviction. We talk of eviction, builder goes to court, court says evict him, throw him out, majority. If I have a right to occupancy given by society, then how can I be evicted and not given an alternate accommodation immediately moment I am leaving my place? I need a place. If it is not given to you, then deficiency of service. Society has failed to give me accommodation. Consumer court may look at it. I have not seen the case. Maybe it is not tried and tested, but this is what the logic says, and that's what I am explaining. Now we have got a situation of corpus. We have got the station of income. Those are all separate allowances as an arrangement of a contract with a third party that, okay, I am accepting the dehousing, but I'll undergo some inconvenience. Somebody will pay me something. And if I'm having some corpus, which is the value of the goodwill, because when I'm giving away my flat, I'm giving my right on the land. Because right now, in the current situation, we have the land on which flats are constructed. So in 100 square foot, you may have 4 flats of 25 square foot each on the ground floor. Then you will have on the first floor, you will have on the second floor, and so on. But the upper floors don't have land below them. The land is only below the ground floor. So what happens here is that the right to the land to construct is then given to the builder, that you can come and construct the floors on my land. The land still remains mine, which is the first statement I had made, conveyance. If the conveyance in the name of the society, the land remains in the name of the society. Once the land remains in the name of the society, then we give them the right that on this land you can construct. Now when you talk of land, a very curious situation arises. When the builder sells the flat, he does not sell at construction cost. He sells at the market price of a flat, which includes the cost of the land. But the land is already exhausted in your building. So he gets that value of the land, which is an invisible thing. So if the flat is sold at 25,000 rupees a square foot, 5,000 is the construction cost. The builder picks away 20,000 rupees from the new buyer as price of the land which he does not own. He does not own that land. The land belongs to society. So when we do our feasibility, or when we do our projection, or we do the potential of our building, before we get on to redevelopment, all these things individually have to be checked out and seen, which I'm not sure whether members get a chance to look at the mathematics of the calculation, how your rent is arrived at, how your inconvenience allowance is arrived at, how your corpus is arrived at, and how the area which builder gives technically does not give anything because it doesn't have anything. But we assume that the builder is doing a favor, so that needs to be corrected. Builder does not give you anything. Everything belongs to the member. Builder takes away everything, makes you zero, and then start to redistribute it back to you. And we feel very happy and we thank him for it. Correctly speaking, the members should do the entire costing and then tell the builder what we will give you. And if you like to take that, come and construct. If you don't like to take that, please stay off. And whoever wants to construct, you come and construct. And if nobody wants to go for construction, go for self-redevelopment. It is your property. Make the food at home. You don't have to go to a restaurant to eat the food at all the time. Not necessary. Question there arises is, oh, if I go and make ourselves, who will do it? We have no time. Let me tell you that most of the builders, except a few who have got a full team, have no team. It's a builder, a single person, maybe having a company with a very small share capital, with a bank loan done on your property, and then he starts to engage an architect, he starts to engage a builder, he starts to engage a PR. We can do the same thing ourselves. You can engage a PR, you can engage an architect, you can engage a developer knowing the cost, and even tell the builder what you want to have in your building. You can lay down the specifications and get a tender for that and give it out to somebody who will complete and put a penalty clause. If you don't complete in 3 years, you will have to pay a penalty of X amount. Very simple. Then the question is, what happens to money? Where does it come from? People can buy the flats in advance. Once it is society's own property, you are buying the flat from among yourselves. So there's no question, a lot of taxation issues convenience are given. And pay that money in advance. Because for every 10 flats that you sell, you can construct 100 flats or 80 flats. The cost of construction is 6,000, price is 60,000. So 1 to 10 or 50,000, 1 to 5 is the ratio. So for every 10 flats that you sell, you can construct 50 or 40 or 60 depending on the construction cost that you want to have. It's a very simple calculation, but you must apply your mind. Unfortunately, neither the PMC, nor the legal team, nor the builder gives you those options. And these options, I repeat again, have to be taken. Members have to take these options prior to getting into any redevelopment agreement. Prior to even thinking of deciding to go for redevelopment. First do your mathematics, get your figures in order. There are a lot of project accountants available, a lot of chartered accountants in the practice of project accounting. They will do a proper project accounting for you and give it to you with the complete projection, which can be done by any independent architect. So an independent architect together with the chartered accountant will give you a full set of mathematics which will tell you what is the potential. And feasibility and potential have a difference. Feasibility is a commercial viability, potential is the net worth of your property. Commercial viability means if I build and give so much, will the money be remaining to give it to the developer? Answer is yes or no, you get here. Potential means what is the intrinsic value. Intrinsic value would mean where your land is located will have a value. What sort of a location is main road, common road, commercial practice, bank can come in, what cannot come in. That is the potential, not purely construction cost. Then you have what fungible FSI will come, what TDR will be loaded, how high it will go, whatever the technicalities are there, and what are the costs of all those things that you are doing. Now, why I'm explaining this is the role of the auditor, because our title is role of the auditor. The auditor who comes to audit has to make a detailed understanding and make a report to the society which is interested in going for redevelopment. Auditor has to see that is the society, so when they come for the audit, they would ask, is the society likely to go for redevelopment? If so, what are you doing about it? The committee says, oh, I'm going to issue a notice to call for a meeting. The auditor would say, no, there is no provision. There is absolutely no provision in the bylaw for the committee to initiate a redevelopment. They cannot. The people who own the flats can only initiate, and there is a procedure for it. And the procedure is given in the GR. The GR that we are talking about, whether it's substantially acceptable, not acceptable, under 79, lays down each and every procedure. Now, what is the procedure? The procedure says, if more than 1/5 of the members who want to go for redevelopment, and this is clause 5 of the GR, it says not less than 1/5 of the member of the societies who are intending to undertake the redevelopment of the building of a cooperative housing society should, I repeat the word, should submit an application for arranging a special general body meeting. So the application has to come from 1/5 of the members, and this is not under section 76. This is under 79A. To decide the undertaking of redevelopment of them with their plan and suggestion. So the members who want to do, the 1/5 of the members just don't have to write a letter. Please call for a meeting to help redevelopment. No. Let them go and make a study. Let them go and make the preliminary understanding with a plan and suggestion regarding redevelopment of the building and address it to the secretary of the managing committee. So it should be a full docket. And then on receipt of this document, the secretary will employ or engage together with the managing committee approval an architect. The architect will then study the plan and proposition and tell you it's viable or not, potential is there or not. And if it is there, the meeting has to be called within 2 months, not 1 month. So section 76 gives you 1 month, section 79A gives you 2 months. But the document should be accompanied by a plan and proposal. If the plan and proposal is not accompanying the requisition document, then the committee cannot call for a meeting. That's very, very vital. The agenda of the meeting should be given to each and every member, and a 14 clear days has to be given. And the project report and redevelopment of the building with the project management consultant. That is where the first project management consultant comes up, which is the PMC. On the panel of the local authority comprising of registered architects and the Council of Architects under Architect Act. So that is the third portion, not the first portion. It is not the PNC that you engage first, who then tells you what to do. You put the cart before the horse, not the horse before the cart. So that is the first thing which the members have to make sure is put in place. And then we go to the next step. The next step is all laid down in clause number 6, 7, 8, 9, 10 up to 20, which has to be followed. Now go back to the very first preamble of the resolution or the GR. It says the GR has been made keeping in mind that the committee is not taking into confidence the members of the redevelopment process. There is no transparency in the tendering process. That comes because the tendering process is done by one committee who looks at 10 and decides to throw away 5 and only pushes 5 back, or more nowadays in the case of so-called associations that are being formed. A lot of places associations are being formed of societies. An association calls for the tender process. Association has no business because it is an association of societies. It is not an association of members, and the flats belong to members. So there's the first violation which happens when an association starts to take the lead. An association, even though there are representatives of the different societies, can never take the authority of owning the building or the land of the society. The third thing is appointment of contractors at one's pleasure. All the contractors, lawyers get appointed by members of the committee or by an association, who then gets the society to pass the copycat resolution. Okay, I also approve. So far as lawyers are concerned, if I'm appointing a lawyer in my society, I have to throw the names to all the people if anybody has a clash of interest. If there's a clash of interest, then that lawyer cannot represent the society members and can never be appointed. When it is a question of association, this exercise is not done. A lawyer gets appointed with the pleasure of the people in the association, and then you find that few people have got cases of their own with the same legal company, and then the problem starts down the line. Then we find that there are no coordination between the architect and the project consultant. There are 8 such things, including looking at the redevelopment agreement. The last item is no uniformity in the agreement executed by the developer. So an auditor has to look at all these things to ensure that the compliances are done. The registrar has to look into these to see that compliances are done. But unfortunately, all these steps are missed out. And what we really have in real life is the committee decides everything. People don't question anything, or if they question, you don't get the answer. If you go to registrar's office, you are tired of going and coming. By the time your turn comes with all good intentions, you don't get the result in good time. And then it has already happened. And then the lawyer advises, rush, rush, rush. And in a rush, you find that general bodies are called overnight. Tenders get appointed overnight. Everything gets done overnight without the agreement being vetted by the member and his own lawyer. Any agreement which is not vetted by the member's own personal lawyer may have problems which will lead to potential problems. And in redevelopment, slow and steady wins the race. And wherever they have gone in a haste, let us do it quickly because we'll get a big house and a big flat, the problems always come in. And then we see situations of blaming and a blame game starting. So auditor's role is very, very vital. Every auditor in his report should state that I have received a confirmation from the committee that the procedure of 79A has been followed. Or he will write and say, I have a certificate given by the registrar. Now I'll jump to the registrar's part. A registrar ought to, because the entire enforcement of the law is given to the registrar. Registrar has the power to enforce the law. So we need to work out how a registrar would do it. Now we'll take a short break before we get on to the subsequent portions.
Hey everyone, Nausheen Ali Sardar here. I just wanted to take a moment and talk to you about something incredibly important, our rights as citizens. You know, knowledge is power, and understanding our legal rights is crucially important in today's world. That's where Citizens Justice Forum comes in. Citizens Justice Forum video channel is doing fantastic work empowering citizens by sharing valuable legal knowledge. They are dedicated to helping us understand the fundamental rights given to every citizen by the Constitution of India, from insightful discussions to breaking down complex legal jargon. Citizens Justice Forum is making legal information accessible to everyone. It's like having your own legal guide at your fingertips. So, if you want to empower yourself and stay informed and be aware of your rights, make sure to stay connected with Citizens Justice Forum. And don't miss out on their fantastic content. Subscribe to their channel now and let's build a community of informed and empowered citizens together. Knowledge is power, after all. Stay connected, stay informed, and subscribe to Citizens Justice Forum. See you there.
Welcome back. That was a bio break for everybody. The subject is a bit serious and sensitive. And my sincere request is, before you get out of your flat and you give away your flat and you are on the road, please ensure that every aspect of what I have suggested is ticked off. Yes, 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 yes. Now I come to the second box, which is the managing committee's role. And then we'll go to registrar and we'll go to the developer in different parts. The managing committee has a very small role to play. They are representing the members of the society. The management is vested in them and they act as trustees. So on their own, there is a delegated power given to them to run the management of the society, which is the day-to-day activity. employing a gardener, painting, repairing. And in the context of the bylaw number 5, to administer, manage and maintain the building, to obtain the conveyance, and to carry out other activities in cooperative spirit, and to do other activities in line with the cooperation. So these are the things which the managing committee has to do. Now, before the managing committee gets on to do any other thing, which is redevelopment, nowhere in the bylaw the redevelopment activity is vested in the managing committee. Please remember. Managing committees may claim they have the right, but bylaw does not, because it is not the object clause. So obviously the managing committee cannot have an assumed right. So a right has to be given to the committee by a resolution. When they decide that we want to go for redevelopment, then a resolution has to be passed. Once the 1/5 have applied, they have given a plan and proposal. Committee has got the power to call for, under 79A, a power is given to them. They are empowered to call for the architect and to look at the plan. But then it goes back to the general body again. Beyond calling for the architect and getting the details, managing committee is not given any powers at this stage. Subsequently, yes, but at this stage, no. So now, once we are at this stage, it goes back to general body. And in the general body, 51% have to say we want to go for redevelopment. Now, question is why 51? Why not 52? Why not 49? 51 is a simple majority. Second thing you must understand that, as I spoke earlier, it is on a small piece of land, which is common divided interest of every member going from ground to 50th floor or 40th floor, have an interest in the land. That is why if 51% of the people living in the flats over the same plot of land say yes, the small land which belongs to 200 people, 51 people want that land to be redeveloped, then it is a good majority, simple majority, and redevelopment exercise can be put in motion. I repeat, can be put in motion. So managing committee only has the power to say, okay, fine, now that it is put in power, give us the powers. What are we supposed to do? Because bylaw does not give us any power, Act does not give us any power, the resolution does not give us any power, GR does not give us any power, till we complete certain things. So when you give the power, the members are giving it to managing committee. And I would also request the managing committee to pay attention. Don't take on more power than what you should, because the consequences of that power for not performing will fall on your personal head. Because if the managing committee does not perform, then the members have the legal right to proceed against the managing committee for whatever losses they may suffer, because you have asked for that power and you have been given that power and you have failed to judiciously exercise that power or in the interest of the members, because the managing committee then becomes a trustee of the flat owners. So when you are making a resolution to give the power, you must put a clause that it's our land belonging to the society and the committee is a trustee for all of us, and in the interest of all the members will carry on the following activities because we all cannot carry it out. Question is then, why does the legal department not give you those ideas? You may ask your legal advisor why he has not given you. He may have an answer, or he may say, oh, the builder is my friend, I don't want to do this, or the committee is my friend, I don't want to do that. But as a member and your property, it is your duty to ensure that you are protected 200%, not even 100%. Whatever resolutions are to be passed, please take those resolutions to your own lawyer. You are giving away your flat. Please take those resolutions to your lawyer. Ask him to amend it if he finds that there are some words in that resolution which is taking away some of your powers under any circumstances. All these things are not being done. Transparency does not exist, which is the first preamble of this particular guideline. Thereafter, we have this issue of the resolutions giving them the process. And there should be one more resolution that at every stage and every 30 days or every 40 days, document done by the committee will be given to general body to ratify. So at each level, the general body must ratify. Just the way when we give a power of attorney to somebody, we say power of attorney to be ratified by the giver of the power of attorney. So it is not an open right. Most of the times I've seen resolutions, they are open. Committee is empowered, secretary is empowered, chairman is empowered. No, nobody is empowered. You can't give away your powers to anybody, only selectively, piece by piece. So power is to be given for unit 1. Divide your process into 10 parts, give one part, he comes and gives you a report. It doesn't matter if it takes time. It doesn't matter if the builder is saying it will take me time, it will do this. It doesn't matter. Your flat is more important to you than the profit of the builder. Builder is not, he is not the proper, he is just a process for the action. He is not the action. He is just the process to reach my goal before I get rehoused. That is where the issue. And managing committee has to ensure that the last box, which is rehousing you back, is discussed at the same time when they are discussing evicting you or taking you out or dehousing you. So dehousing and rehousing should be decided at the same time. And when the registrar's role come in, which I will discuss in the next chapter, he has to ensure that the people who are being taken out are also given assurance in a proper manner that they will be brought back within a specified time. Those areas are missing. They don't exist either in the report of the registrar or in the powers given or in the redevelopment agreement. So these are the few points between the member and the MC. Now I would take you across to my colleague, Mr. Afzal, because some questions have come in on this matter. So he would probably take the questions and I would give you the answers.
It is very, very important to understand that when your society is going in for redevelopment and when you have put your trust in the managing committee, it is very important for the managing committee to be transparent. And see, the question is, you are dehoused and you leave the premises and you go. Now, general tendency is कि हमने managing committee को सौंप दिया है redevelopment का issue और अब वो ही देखेंगे. यहीं पे आप गलती करते हो. It is very important that you have to be alert at every nook and corner of that particular project.
Very important.
You need to have a WhatsApp group of redevelopment.
That is always there in the group,
yes.
So they will have.
So it becomes very important for the managing committee to share all the details at all the time with the members. At the same time, the members also should take that initiative, and because it is your hard-earned money, आपने किसी के ऊपर जिम्मेदारी छोड़ दिया और आप भूल गए, ऐसा नहीं चलेगा. You are going to face a lot of problem. So very important that you, whatever development that is taking place, the managing committee has to share with you. At the same time, the members should also, they should also, ask questions. They should also check it. जैसे असरानी साहब ने बताया, they should check it with their lawyers, whatever resolutions that are there, and only when all come together, then this redevelopment can be a grand success.
Can be a success. And we have issues where the committee is in disagreement with some member, and the member forms a technical loophole and applies for the dismissal of the committee or the removal of the committee or the disqualification of the committee. Then you have a situation of three groups formed in the society. One is the group of the disqualified and his people. Then is the other group left out and the group of the complainants. The builder takes advantage of that situation because when there are three monkeys, the gorillas eats. So that is the old story we have all learnt in the school, that we have to be very, very careful that we safeguard ourselves. And if there are regular meetings where every 2 months you call for a special general body meeting and the managing committee lays threadbare all the papers on the table and say these are the things. So if any course correction is to be made, then the course correction can be made properly. We start hearing even through court orders that majority and minority and things like that. In transparency, there cannot be majority. Transparency has to be 100%. You can't have transparency 51%. You can't make transparency in the agreement copy they are not being there and say 51% of the terms are okay, so agreement is okay. You can't have 51% in a tendering process. They have to be 100%. So there are so many things in the complaints which have to be 100%. And once we say, okay, fine, now everything is 100%, or the members get together every 2 months or 3 months, and all the papers are put before all the members, they satisfy themselves, give a correction, consolidate, and then move out. That's why this way that I talk about dehousing, consolidation, and rehousing. And rehousing should be decided before you vacate the flat. It's not the rent. You will get the rent, and so many cases have happened where after 1 year the rent stops coming. You are under assumption you will get the rent, you don't get it. Some excuse or the other comes up. You are all dehoused, you are in different parts of the country, you can't meet, you are lost. So the opening end and the closing end should be tied up properly before you go out. And to the managing committee members, the chairman, secretary, treasurer, you are also a member. If the project comes to a halt, your flat also is at stake. There may be some committees, I don't say 100% correct, there may be some rogue committees who may have private arrangement, but in general my experience is that the committee works quite transparently, works quite honestly. But there are rogue committees where we may have situations. But if your flat is there, please take care and do your own precaution. Buyer, be aware. If you don't take your own precaution, you won't be able to go back to court later to seek justice, because you have waived your rights to the managing committee and to the developer and to the legal team and to the PMC. You have a right to question the PMC at that meeting. If you are not happy with the PMC, put a term and condition on his clause that after every 3 months, if you find that he is not answering correctly or leading us wrong, and majority people decides that the PMC can be asked terminated and get a fresh PMC, there is no issue. If you find that your legal advisor is not giving you the correct advice, in his appointment order, you can put a clause that if more than the majority find that the legal advice is misleading, you can terminate the contract. It can be part of the contract term. Your safety is first. You save yourself, you are happy. When you start to save the managing committee, you start to save the builder, you start to save the legal team, you start to save the PMC by ignorance. Because nobody will go out on his own to do that. Out of ignorance of law and your rights, you don't pay attention, and your action gives them the savior, then you have a problem. So I have completed the part of the members. I have completed the part of the managing committee. We have 2 more parts, which is the developer and the registrar. I will take that in the next session because we have a time constraint of 1 hour, and I think we have exhausted the time. So
we can, taking clue from what you have said, I would like you to enlighten the citizens that, as you said, that if there is a resolution, it has to be, you have to take it to your lawyer and take an expert opinion. So at what stage, what documents need to be consulted with your individual
every stage, every document. You don't know nothing, because the documents that you get are drafted by people who are experts. You are not an expert. A comma or a full stop will make a difference in the document. So please find out a good expert to whom you will carry your document. Be prepared to pay the fees. Your flat is worth 5 crore, 6 crore, 3 crore. Fees will be in thousands, maybe whatever. It's a very small price to pay to save your crore flats. So never go under the impression that जो वो बोल रहा है सोसाइटी का लॉयर है ठीक बोलेगा 90% ठीक होगा, but you may be in the 10% which is not correct. And right now we have got more than 70% of redevelopment which are stuck.
Absolutely.
So there is something wrong somewhere. I cannot lay my finger on at this moment. So one must be very, very careful. And as I said earlier, if there is some member who finds a technical fault and the committee gets disqualified, then you have nobody knowing nothing. And you also know nothing. So if you are not having things done in a proper manner and in a transparent manner, then this question of debarring will not arise. If the managing committee, why does the managing committee get debarred? Because they are not following the GR. Then whatever may be the cost, whatever may be their way of getting an order contra to what has been issued by making arrangements or whatever it might be, the whole project has to suffer at the end of the day because it is inconsistent with the logic. So by feeling that, oh, we got an order that it is okay, you don't need an order. Managing committee does not need an order. Let them read the GR and go 2 steps more. If the GR says take 5 steps, you take 7 steps. No harm. But make sure that everybody's interest is protected. Make sure there are no egos. Make sure that there are no private contracts. Make sure that the builder does not come and offers you a greed of any kind. And don't fall for these tactics and tricks. Because once you fall for that, then the bottom line is, end of the day, the project will suffer. Otherwise, on its own, if the project is very well done, there is no reason to suffer. So these are the remarks which I would like to answer with.
As you said, RERA and the government is coming out with a standard agreement. So what happens is, always a builder's agreement is one-sided. So when we say that you need to have everything checked with your individual lawyers, makes a lot of difference. You can always have your safeguards in place. So whenever at any stage you feel, please consult all the documents that are given to you for redevelopment. You can consult with your lawyer, get it checked, try and if he feels that certain clauses are not in your interest, he will propose that it should be changed, get it changed and put your foot down. Now, there was one more question that people were asking last जो session हुआ था हमारा, तो उसपे ये है कि the tender documents were issued, tender documents were opened, the financial part and the technical part, and it so happened that suppose 10 builders had come and all of them were not in conformity with what the managing committee was wanting. Under that circumstances, one person wants to know that what is the next step?
See, the first question itself is giving the answer. Managing committee wanted. Put all the 10 on the table. What's the problem? If you have 10, put it on the table. Let everybody see it. And let people say, ये ठीक है, वो ठीक नहीं है. आप जो आप बोलते हो वो ठीक है. I accept what you say. But lay it on the table. Why would you do it in a way that only one person turns up at the final appointment order, or only 2 turn up on the appointment order? The rest don't appear. Their names are not there. So all the names should be there. The background should be there. Interviews should be there. Let it take time. Most of the general body meetings that are held, which I have seen, don't even last for 20 minutes. People assemble, the registrar man comes and sits down there. How many for this, how many for that, come before the video, say I vote for so-and-so, and it is recorded. That is a meeting. You are giving away your flat with a voice vote to somebody you don't know. How would you do that? But it is being done. And managing committees should make sure that they give enough opportunities. Let the meeting last for a whole day. It's a lifetime question of giving away your house. Let the meeting last for the whole day. Why a meeting has to last only 20 minutes? Why the rush in the meeting? If there is a matter which still has to be resolved, or there is a dispute still to be resolved, then why do we have a situation of people rushing a meeting? Take your time. There's no hurry.
After all, it's your hard-earned money.
Precisely.
And you may lose
So you
everything.
want to conclude?
What I would say is, if you have liked this session, kindly subscribe, share with your group, and press the bell icon. Till then, stay blessed. Thank you.
Next Saturday, 7:15.
7:50.
Thank you.
Thank you.